Please remember that you can find additional information on tonight's topic on Equine Business Network's live webcast on utilizing volunteers and students. Please remember that you can find additional information on tonight's topic in the course site, including the recording of tonight's webcast, a PDF version of the presentation, a decision-making tool exercise, and additional resources. The presenters this evening include Roger McEowen and Erica Eckley. Roger is a professor in agricultural law in the Department of Agricultural Education and Studies at Iowa State University. He is also the director of the Center for Agricultural Law and Taxation. He is a member of the Iowa and Kansas Bar Associations and is licensed to practice in Nebraska. He is widely published in law reviews and in other agricultural law publications and conducts agricultural tax and law seminars across the country. Erica Eckley is the staff attorney at the Iowa State University Center for Agricultural Law and Taxation. She graduated from Drake University Law School, where she was articles editor of the Agricultural Law Journal. She has also been an associate lawyer and a judicial law clerk in Iowa. She is a member of the Iowa State Bar Association and is admitted to practice in Iowa. Please note that you are still able to ask questions tonight during the presentation via the text chat on the left of your screen. We will be emailing these questions to Roger and Erica so they can answer them next Thursday at 7 p.m. Eastern Standard Time. As a reminder, the presentation today will be recorded and uploaded to the EBN course site if you want to review the talk at a later date. And at this time, I will turn the presentation over to Roger and Erica.
Thank you. I want to say good evening to everyone. Tonight we're talking about using volunteers and students in your horse business and the constraints and restrictions that might exist in doing this. In order to look at a general overview of what is allowed and what is not allowed, we're going to focus on the Federal Labor Standards Act. While this is a federal law, there might be state laws that will mirror this statute. They might apply to smaller organizations, and they might be more restrictive than the federal law. But for tonight, we're going to focus on the provisions of the Federal Labor Standards Act. And this applies to all employees within the United States that are from the government agency, or a hospital, a school, or a company with annual dollar volumes of $500,000 or more. Again, state laws might mirror this statute, and they might apply to smaller organizations within the state. So you should look at your state law to determine if you are covered under that. But as we discuss volunteers tonight, we're going to focus on the definitions and requirements under the Federal Labor Standards Act. The Federal Labor Standards Act defines volunteers as unpaid individuals. Usually they're part-time. Services are given for public service, religious, or humanitarian objectives. Volunteers are not employees. A couple weeks ago, we looked at the distinction between independent contractors and employees, and we found out that if you have an individual who is an employee, there are specific requirements that you do have to meet for taxes and other reporting and paying. Under the FLSA, if you have a volunteer, this would not apply. However, employees may not volunteer for for-profit sector employers. So if you are a for-profit private sector employer, you do not have volunteers that can come and do services for you. One exception would be is if there was a charity event or something similar that was being sponsored by the private sector employer, such as a fundraiser for cancer awareness or various things like that, in which case you could have individuals who are volunteering for that humanitarian public service type activity. But in general, for-profit employers cannot have volunteers. So looking at cost savings that might, thinking that using students or volunteers to save money, typically you're not going to find any cost savings in this just because of the disallowance of using these individuals to replace employees. So if you do have employees that are going to do any volunteer work for you, or if you are a nonprofit and you have people who are volunteering, you want to make sure that they meet the definition of volunteers. You want to make sure that they're doing it for their own personal reasons. There is no employer coercion of any kind. They're doing it part-time, and they're not doing activities that paid employees are doing. So you can't have somebody show up and volunteer to do a job that you have actual paid employees, specific job descriptions for those people. If you do have volunteers who actually should be employees, this misclassification can result in back pay or overtime awards and penalties, which can be quite significant depending on how long the activities have occurred and how many people are involved. So if you are going to use volunteers, we suggest you check with an attorney before moving forward with volunteers. If you have employees who are volunteering for some kind of humanitarian nonprofit fundraiser activity that we talked about earlier, you want to make sure that you keep track of the time that the volunteers are actually working on those, clocking in and out on those activities, so there isn't any kind of discrepancy about when they were actually an employee, when they were actually a volunteer, so you don't have any misclassification, back pay owed, those types of things. It's really hard if there isn't documentation at the time to recreate when somebody was actually changing hats, so to speak, between being an employee and a volunteer. So if you have a situation where you're asking or your employees are volunteering for some kind of humanitarian purpose, you want to make sure you keep track of that. You also want to have policies for all volunteers. So if you're a nonprofit who has volunteers that come in and work, you want to make sure that you have clear policies of what a volunteer is to do and what you expect from them and the type of activities they're going to do and hours they're going to work. You also want to make sure you still provide training for any kind of safety concerns if you're going to be having people handling animals, dealing with equipment, various things. You want to make sure just because they're a volunteer doesn't mean that they don't still have the safety concerns and that they need the safe environment in which to do their volunteer work. I'm going to transfer over to Roger to talk about the Federal Volunteer Protection Act.
Thank you, Erica. Another piece of federal legislation that will cover nonprofit organizations as well as government entities that have volunteers that are performing tasks on their behalf is the Federal Volunteer Protection Act, or the VPA, that was enacted in 1997 almost unanimously by both the House and the Senate at that time. And the intent of this law is to promote volunteerism by limiting or eliminating a volunteer's risk of tort liability when they act on behalf of a nonprofit organization or a governmental entity. So make sure you're aware that this only applies when we're talking about nonprofit organizations or government entities. And the primary requirement under this law is that the volunteer has to be following instructions and acting within the scope of the authority that they've been cloaked with by the nonprofit organization or that government entity. So they're, in other words, they're doing what they're supposed to be doing. They also, if applicable, need to be properly licensed, and they must be qualified to perform the particular task or the act at issue. Willful misconduct, gross negligence, or criminal behavior is not protected. This only covers ordinary negligence, and we'll give you an example of that and talk a bit more about that. If you look at an example, let's take Mary, for instance, who volunteers for a horse stable. That horse stable is a community nonprofit organization. And Mary unintentionally but negligently fails to close the gate to the stable, and a horse gets out, wanders onto a road, causes a vehicle accident, and Mary gets sued. Well, the act is designed to address the liability potential that Mary has in this type of an event and would shield her from liability for what we call ordinary negligence. So the very simple or ordinary negligence, such as forgetting to close a gate, as in the example of Mary, would be covered by the VPA if we assume, and we're assuming in that example, that she's acting within the scope of her responsibility to the eligible organization. Is she doing what she was supposed to be doing when she was picked up by that organization to do some volunteer tasks for them? Again, it only protects the volunteer. It does not protect the nonprofit or governmental entity. So that could, in some instances, give rise, this situation of Mary could give rise to some questions at a jury trial as to whether there was sufficient involvement by the organization in monitoring her activities and guiding her activities, controlling the scope, the course, the conduct of her activity. Is the organization involved somehow, or was this just purely a task that was assigned to Mary as a volunteer? Also, the Act does not cover damages caused by acts involving motor vehicles, certain type of violent crimes, hate crimes, sexual offenses, civil rights violations, or conduct involving alcohol or other drugs. So as you would imagine, if you just kind of use common sense, many types of liability provisions that create some sort of, I suppose we could say, immunity will not cover these types of offenses. So it's a very common list that we see in a number of different types of statutes. So immunity provided under the VPA is qualified immunity. It is not absolute. Again, it only covers simple or ordinary negligence, and states, of course, can impose conditions on a volunteer's immunity. If we look at the mechanics of the statute, if we kind of go through the major statutory sections of the VPA, and again, you can find this, as we noted on the beginning slide of this section, it's in Title 42 of the United States Code, starting at 14501. But 14502 sets forth the rule of federal preemption. And what we mean by this is that the law preempts and nullifies any state tort laws that that deal with these types of situations, to the extent those state laws are not consistent with this federal law, unless, of course, the state law provides additional protection to volunteers. So what that means is that the states cannot strip away protection and have looser rules for volunteer conduct for these types of organizations, the nonprofits and the governmental entities, than what the VPA provides. Now, states can opt out of the VPA, and New Hampshire has, if the volunteer and all parties are citizens of New Hampshire. But most states indeed have not opted out of the VPA, but there is that opt-out provision. Section 14503 is where you see the definitions. This defines the basic liability protection for volunteers. The volunteer organization can still take action against the volunteer. In certain circumstances, that may be the case. The immunity only applies, again, for the volunteer. You've got that state opt-out rule, and it applies to all types of damage. All types of damages. You can only get punitive damages under the VPA if the harm resulted from the volunteer's willful or criminal misconduct. If they went out and intentionally damaged someone or someone else's property, then punitive damages might be applicable in that situation. Or if there's conscious and flagrant indifference to the rights of the injured party. But punitive damage is going to be very rare. Most situations, you do not see punitive damages. The purpose of punitive damages is to punish the offender, to make sure that really the point is driven home that they never do this type of egregious conduct again. With respect to most of your volunteers, somebody that's volunteering, they want to be doing this. They're doing this on their own time. They're not really getting compensated for this. So if they're getting compensated, it's very minimal. And we'll talk about how the VPA covers compensation issues in just a second. But the vast majority of situations, you're not going to be dealing with punitive damages at all. Now, certain conduct does not give rise to immunity, and there are some unique, probably not worth talking about, but unique provisions under 14503 where there is no immunity that's provided. Section 14504 provides protections for non-economic type losses, and the rule of proportionate liability comes into play there. 14505 is where you have the definition of what a volunteer is that's covered under the provisions of the VPA, and that is someone that receives no more than $500 in compensation annually for serving as a volunteer. Doesn't matter what their title is, doesn't matter what office that they're given as a volunteer. And you can have volunteers that have a pretty shiny title or have a high-level office in the organization, but the VPA does not care about that. Also, if you're concerned about this, 42 U.S.C. 14505 is where you will see the definition of a nonprofit organization. So, Erica, why don't you take it over and talk about the School to Work programs? That's kind of the next segment of the discussion.
Thank you, Roger. Now that we've concluded discussing most of the provisions dealing with volunteers and how they might affect your business, let's talk a little bit about using students and young adults, youth in your business. And one thing that you could be involved in is school-to-work programs. School-to-work programs must be primarily learning experiences. It needs to be a planned program of job training and experience for the student. There needs to be a sequence of activities that increase in complexity, structured to expose the student to all aspects of industry, and provides for real or simulated tasks to develop critical thinking and problem solving. So basically, this needs to be organized through either the local middle school, high school, or vocational school in your area. You need to work with the educators, and it needs to be a actual curriculum type program to qualify. And the Federal Labor Standards Act has more specifics about exactly when a school to work, when an individual is a school to work trainee or student. And basically the criteria is that the training needs to be similar to something that might be given by a vocational school. So if you're dealing with children still in high school and it's been given through the high school, this is something that would be similar to what might be given at a junior college or various vocational training that somebody might occur. It's for the benefit of trainees or students. This one is kind of complicated. This basically means that you are there to help the student learn. The program primarily is for these trainees, these students, to get experience, to understand how things are going. This is not something that is going to immediately benefit your organization through not having to hire employees because you have somebody doing these tasks that this individual is doing. In fact, you cannot displace regular employees in order to have the trainee come in. So if you have trainees come in, you have to keep your regular employees, but the trainees need to have close supervision. They need to be doing their tasks under close supervision of either you or some kind of management. Somebody needs to be keeping track of these trainees so that they are using this as a learning experience. They are having the wisdom of individuals who have experience in the arena to really provide the training for them. And another thing that they look at is that the employer receives no immediate advantage from the trainees, and in fact operations may even be impeded. This is basically, you're providing training, so you're going to take the time out of your day to supervise the student, to give them feedback, to make sure that they are doing that learning environment. And basically, any productivity that your organization might have needs to be offset by the burden on you for the time and effort in the training. The other thing that they look at is that the student would not have an automatic entitlement to a job at the end of the training period. So this is not something in which you are specifically training somebody who's going to come in and be your employee. This is a general student learning environment. They're not being trained specifically for your organization. And a final thing is that there's a mutual understanding between the student, the employer, and the parent that the student is not entitled to wages for time spent in training. You can provide a stipend if they need books or tools or some other type of document or tool in order to do the job. That is not considered compensation, but there needs to be an understanding that they are not being compensated. They are not employees, they are trainees. So let's look at if you just hire a child or youth to come work on your organization, at your organization. And we're going to look at the federal child labor laws. You should know that other federal or state laws may have higher standards than the Federal Labor Standards Act. So you should become familiar with your specific state laws if you do have a number of children who are employed in your operation. States also have child labor laws. They also have compulsory education attendance standards. We are going to talk a little bit about certain children of certain ages and the requirements that they not work during regular school hours. But you want to make sure that you also are not in violation or putting the child or their parent in a situation where they might be not following the compulsory education attendance. States also can determine ages and conditions for operation of motor vehicles. So if you have a child or a youth who is operating a motor vehicle, you want to, we're going to talk about the Federal Labor Standards Act, but you want to make sure that they are of age within the state to have the license to operate the machinery. You also know that agriculture has special rules under this act. Agriculture has special rules under a lot of the acts just due to the unique nature of agriculture. So one thing to keep in mind is that if you have children who are going out and cutting their neighbor's lawn or occasionally babysitting, they're not necessarily covered by the Federal Labor Standards Act. My brother was quite enterprising when he was younger, and he went door to door to try to collect lawn mowing business. I think at that time it was $20 a yard, which I think he did pretty well on that. But he is not in violation of the Federal Labor Standards Act. He's just sort of doing that on a casual basis. Also, children of any age that are employed by a parent on a farm owned or operated by the parent are exempt as well. So that's one thing to look at is are you the parent of the child, and are they working on the farm owned or operated by you? Minimum age standards. So if you have somebody under 12, and again, this does not apply to children employed by a parent who are working on a farm owned or operated by the parent. If you have somebody employed who's under 12, they may be employed, but it must be outside of regular school hours. There must be parental consent, and it has to be on a farm where the employees are exempt from the federal minimum wage provisions. If you employ somebody between the age of 12 and 13 years old, they also may be employed, but it also must be outside of school hours. So if school is in session, they cannot be working during the time that school is in session. And again, there must be written parental consent, or they must be working on a farm where the parent is also employed. If you have a child that's 14 years old, this would be the minimum age for employment. Outside school hours, and they can do anything except those occupations declared hazardous by the Department of Labor. We'll touch on those a little bit later, but they can do anything except those situations. So if you have 14-year-olds who are employed on your farm, you need to make sure that you are aware of the hazardous occupations that they cannot be involved in. And then if you have 16-year-olds or above, they can perform any farm job, including hazardous occupations at any time, including school hours. So that's kind of the magic number to look at. Wages for minors. Unless an exemption exists, the minors must be paid a minimum wage. This can be computed on an hourly, daily, by piece, or by salary, but it has to average a minimum wage. If they're under 20, they can be paid $4.25 per hour for the first consecutive 90 calendar days of employment. If you have student learners, there can be special certificates, and they could be paid less with the special certificates. You would need to work specifically with the school districts in those types of situations. Also, if you have agricultural employers who do not utilize 500 man days in any calendar quarter or preceding calendar year, they can be exempt from the minimum wage and overtime provisions. So if you have a smaller operation in which you're not employing a lot of people, you might check with your legal counsel to find out exactly whether or not you have to provide the minimum wage under federal and state law. Some of the restrictions on the younger students were school hours and employment. School hours are by statute determined by the public school district in which the minor lives, even if the student does not attend public school. So if you have a child who is tutored privately, homeschooled, it's irrelevant. The school hours would be determined by the public school district in which they live. If they're taken to another area, some kind of migrant labor, then you would look at the school hours in the area in which they are working. So you look at the public school area in which the child is working. You do not look at the home district if they are working in a different place. So you need to make sure that you are monitoring the activities that minors are engaging in, and if you have hazardous occupations, you need to make sure that you are meeting the age limits on this. So the declared hazardous occupations for minors under 16 that might apply to your business would be operating a tractor of over 20 PTO horsepower. So if you have somebody under 16, do not let them operate that type of tractor. Or help disconnect or connect any implements or parts to that tractor. These are not situations in which you should have these minor employees assisting with. You also cannot let them operate or assist to operate the corn picker, a hay mower, a forage harvester, a hay baler. You don't want them involved in a feed grinder, forage blower. These are basically mechanisms that could easily harm a minor who might not be paying as close attention to what they're doing, maybe not as experienced with the equipment as you would want them to do in order to have them operate it safely. So these are the hazardous occupations. Earth moving equipment, power-driven, circular, or band chainsaws. So if you have under 16-year-olds, they should not be engaging in these operations. Another thing to keep in mind is that you cannot have them work in a yard, pen, or stall if you have a stud horse maintained for breeding purposes. That is considered hazardous occupation. They cannot work from a ladder or scaffold at a height of over 20 feet. Also, they should not be driving a bus, truck, or automobile, transporting passengers, or even riding on a tractor as a passenger if they are under 16. Again, continuing with the list of hazardous occupations, you cannot have them working inside any kind of grain storage designed to retain an oxygen-deficient atmosphere, an upright silo within 2 weeks of silage being added, a manure pit, or a horizontal silo while operating a tractor. They should not be handling or applying toxic agricultural chemicals. Again, there might be additional federal laws that apply, so you want to make sure if you have any youth who are doing these that you are following all federal guidelines. You don't want them transporting, transferring, or applying anhydrous ammonia either. There are exceptions to the hazardous occupations. This does not apply to minors under 16 if they're working on farms owned or operated by their parents. So if you have your children working on your farm, these exceptions do not apply. If you have student learners who are in a bona fide vocational program, they may work in some hazardous occupations. They must be enrolled in this course of study, and it has to be recognized by state or local education authority. So if you have a school to work situation in which you have the proper documentation and there's a written agreement, the work is incidental to training, the work would be intermittent and under direct supervision, so this is not the primary task that they will be performing, that you can show that safety instruction is given both by the school and by you as the employer, and that there's a schedule of organized and progressive work processes prepared so that this is only a portion of the work that they're doing. They're getting actual educational experience for this, and you can ensure that they will be safe in handling these occupations. Other exemptions that could apply is if you have 14 and 15-year-olds who have completed some training under 4-H or some U.S. Office of Education vocational agricultural training program, who have a certificate showing that they can operate a tractor. If you have this situation, you need to make sure you keep a record of the certificate, so the child needs to provide you with a copy of the certificate, and you need to keep this on file with the child's employment record that you have. And now Roger is going to complete other things for you to consider.
Eric, I think it'd probably be helpful if we just remind people of what happened over the past, I suppose, year and a half with respect to these child labor laws. The Department of Labor, not too long ago, I can't remember exactly how long ago it was, we have an article on the website that highlights this issue, but the Department of Labor had proposed to really change the rules applicable to teenagers working for people other than their parents. You may have read about this in the media or saw our piece on our website. That generated a lot of pushback from the agricultural community, and the Department of Labor backed off their proposed rules, and it's just kind of sitting there for now. But this is one thing to keep in mind as Erica went through all of these rules. These can be changed. These are regulations, interpretation of existing laws, and the regulatory bodies can change these periodically, and they do. And this is within the domain of the Department of Labor. So just kind of keep an eye on that. If you want to just do go to our website and do a search for this article, you should be able to find it. If you can't find it, just drop us a note, and that'll get you up to speed on what was proposed. And there were some things in there that would have impacted horse stables, horse business operations, and breeding operations, and the like. So just kind of keep that in the back of your mind. Well, as we move on, some other things to consider. Just first of all, some common sense things. Just make sure you keep a copy of the child's employment or age certificate to show that the minor is at least the minimum age for the job. You don't want to violate any of those rules. And every employer, other than the parents of any minor under 18, has to maintain certain records. And those have to include the minor's full name, place where the minor lives while they're employed, what was their date of birth, do they have the written consent of their parents, certificates of completion by 4-H or other organizations if that applies, and a written agreement with a school training program also if that applies. So just some common sense things to keep in mind. Civil penalties, if you violate the rules, the penalties can be rather severe. The civil penalties can reach $11,000 for each employee who is subject to a child labor violation. You can also have an injunction slapped on your operation, which would halt interstate shipment of goods contained or that have been tainted by oppressive child labor, and there may be compelled compliance with the law. For the really bad violations, the ones that are willful violations, criminal penalties can apply, and that would include a fine of $10,000 or 6 months imprisonment on the maximum side of things. So you really want to pay attention to these rules, make sure that none of them are violated. Those can have a significant impact on your business if you do violate the rules. Some other responsibilities for employers of minors. Again, make sure you understand the laws and prohibitions on child labor. Make sure you give training to young workers in a language they can understand and grasp if you've got that issue to deal with, including hazards at the workplace, what are safe work practices. This kind of goes back to something that we talked about in one of the prior sessions, and that is when you employ people, make sure that you've got rules for conduct of employees. It's a good idea to get those in writing, maybe a good idea to adopt an employee handbook. Here we're talking about minors and volunteers. Kind of a good thing to have a set of rules for any volunteers that you might have working in your operation too. Make sure you give training to them. Fire and accident prevention, protocols for injuries. What are they supposed to do if an injury occurs? Now it's hard to anticipate everything that might occur or could possibly occur while they are performing their duties as a volunteer, but just try and sit down and think through possible scenarios based on your facts and circumstances as to what you think might be likely if a problem occurs. Encourage them to ask questions about what their tasks are, what the procedures are, so that they make sure that they understand the expectations. Also make sure any equipment that they're provided is safe and legal for them to use. Label equipment that the minors can't use, that they're prohibited from operating, and also consider the Occupational Safety and Health Administration safety standards, those OSHA standards. Well, what are those OSHA standards for agriculture? There's some basic ones to think about. First of all, OSHA requires that employers furnish to each of the employees' employment and a place of employment which are free from recognized hazards that are causing or likely to cause death of serious physical harm to their employees. There are certain ag-specific requirements requirements, the rollover protective structures for tractors that's been in place for several decades now, guards and protections for farm equipment, how you deal with anhydrous ammonia has specific rules that apply to it. Are accident prevention tags necessary? Hazardous chemicals, how do you communicate those hazards to employees, to volunteers? Those are all of the applicable or the most important OSHA provisions that are applicable to agriculture. Other current issues in OSHA to consider: young worker safety. Kids 14 to 19 could be suffocated in a grain bin when sent to a so-called walk the corn. What are you supposed to do in that situation? Is there a safety harness that's provided? Or what if workers are pulled in like quicksand into a grain bin? Make sure you've got the protections in place to deal with that potentiality. OSHA violations as well as child labor violations can apply when you have young workers that are working on the farm, as well as applicable to volunteers. Also, there's a campaign in place to prevent heat illness. The worker safety precautions have been issued when a heat advisor is issued by the National Weather Service, or NOAA. What do you do with water, rest, and shade? Make sure that the volunteers and the employees have sufficient water, have sufficient rest, have sufficient shade. This is particularly an issue in certain parts of the country with respect to certain types of operations and tasks that are involved in those operations. So what we tried to give you in this session is a quick run through of the major legal issues that apply when you do utilize volunteers as well as students with respect to your horse operations. As you have questions, feel free to send those questions along. You can reach us again at our contact information. There's my information and Erica's email address, contact information, our main line at the center, and again that web address, and we want to make sure that you're tuned into that. We do put out, just as a reminder, a monthly e-newsletter that's free of charge. You can just drop us a note via the website to Tiffany, our administrator here, or you can send an email to either one of us and we'll get it into Tiffany's hands, and she'll be glad to add you to our email newsletter list. That comes out at the first of every month. So again, that's our session on utilizing volunteers and students, and we thank you for your participation and your willingness to listen in on this, and we hope that we conveyed some information to you that you're going to find helpful.
We would like to thank Roger and Erica for their presentation this evening. Just a reminder that this is the third webcast in a 5-part series. Next week we will be having a webcast on ensuring proper documentation to enable employment on horse operations. Again, that's next Thursday at 7:30 p.m. Eastern Standard Time. You will receive a survey by email after the final webcast on March 7th, and we hope that you will take a few minutes to give us your feedback for the Equine Business Network webcasts you've attended. It will help us to better serve you. The quiz and certificate for week 2 is now available in the course site. The quiz and certificate for week 3 will be available early next week, as we need to create the questions based on the presentation this evening. Remember to join the Equine Business Network on Facebook, Twitter, and on our blog for the most up-to-date information on our events, courses, and more. This webcast has been recorded and will be uploaded to the EBN course site shortly. Feel free to send us your comments and suggestions to info@myhorseuniversity.com. Thank you, and we hope you all have a great night.